the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome everybody. Thank you for joining us for today's online talk entitled Corporate Liability Provision under Section 17A of the Malaysian Anti-Corruption Commission Act 2009. My name is Felicia Tang, and I'm an associate with MWKA & Associates, and I'll be a moderator for today's session. Before we start today's talk, let me introduce to you the firm and what we do. MWKA & Associates is a mid-sized law firm that was founded in 1985 by Dato' MWKA. Our able team today comprises of 22 lawyers and a support team of 19. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our firm has 5 practice groups, and our practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 movement control order, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Please visit our website at www.mawkwa.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Allow me to introduce the 2 speakers for today. First, we have Ms. Cassandra Thomazios. She is a senior associate in our corporate department. She holds a Bachelor of Laws from Northumbria University. She was called to the English bar in 2011 and was then admitted to the Malaysian bar in 2012. Cassandra also holds a master's degree in transnational law from King's College London. Cassandra handles a wide range of commercial and corporate matters, which includes drafting corporate project agreements and M&A transactions. Our next speaker is Mr. Tommy Wong. Tommy is an associate in our corporate department. He holds a Bachelor of Laws from the University of Hertfordshire, and he was called to the English bar in 2017. He was also then admitted into the Malaysian bar in 2019. Tommy handles corporate and commercial matters, as well as drafting corporate project agreements and M&A transactions. We will then conclude today's session with a Q&A session at the end. If you have any questions, please don't forget to post it up on Slido or in the chat here, and we will address them at the end once our speakers are done with their presentation. You can access the Slido page by scanning the QR code that is up on the screen, or alternatively, you can do it by going to the Slido website and enter the code 87177. I will leave this slide up for a few seconds so that you can scan the QR code or access the Slido's webpage before we proceed to move on to today's talk. I'll quickly go through the top points for today's talk. Tommy will begin by introducing to you the new Section 17A of the MACC Act 2009. Following that, Cassandra will speak on adequate procedures, the issued guidelines, and defense to corporate liability, as well as corporate liability as provided under the Companies Act 2016. I will now leave the floor to our first speaker, Tommy. Tommy, the floor is now yours.
Thank you, thank you, Felicia. Just let me quickly share. Hi, good afternoon, everyone. Thank you for joining us today for our talk. Also, it is the date where the Section 17A of the Act takes effect. Basically, the new Section 17A introduces corporate liability on commercial organizations in Malaysia for corruption offenses. Previously, the MACC Act only provided for offenses committed by individuals. So what does Section 17A govern? It governs the offense of corruption committed by a commercial organization, whereby a person associated with the commercial organization corruptly agrees to give, promises or offers any person any gratification with intent to obtain or retain business for the organization, or to obtain or retain an advantage in the conduct of business for the organization. And what amounts to gratification? The Act provides that gratification amounts to money, donation, gifts, loan, fees, rewards, and all the other valuable assets that are listed on the slides. Basically, speaking, it means something of value, gratification. More commonly with our daily activities, including being stopped by a police officer, we call it apa macam abang, that kind of thing. And also in business transactions, we call it on table. Basically, in return for an advantage, in terms of Section 17A, a person from an organization provides something of value, something of benefit to another person. It could be another associate person from another organization or an officer from a public body, in hopes to get, for example, a project released from any penalties or disabilities incurred. So what are corruption offenses under the Act? There are four main offenses under Section 16 and 17, also Section 18 and 23. Bribery. Bribery doesn't have to amount to just cash value. You can give property, interest in property, also gifts. There are many questions arising as to whether gifts of small value would amount to such an offense. So the MACC has released a service circular whereby it provides that gifts of small value such as, for example, ang pao, oranges, or hampers for the matter would amount to corruption. What about festive seasons? Mandarin oranges, invitation to buka puasa, celebrations, for example. Well, for the latter, it depends. If it's an invitation towards an officer of a public body, if it is not directly in line with the official dealings of the civil servant in question, then it would be permissible. In relation to Section 23, abuse of public office for pecuniary advantage. This is in relation to where an officer of a public body uses or abuse his position to secure gratification for himself or for his families or cousins. Well, basically persons who are associated to him. Now, well, obviously we all have questions whether, or do we fall under commercial organizations? Do we have to abide by the provisions of the new Section 17A? Section 17A sub 8 provides for the companies and legal persons who fall under the ambit of these commercial organizations. So being a company incorporated under the Companies Act, or even a foreign company carrying on a business or part of its business in Malaysia, a partnership under the Partnership Act, or even from a foreign partnership carrying on its business here, or even a limited liability partnership registered under the Limited Liability Partnerships Act. There are questions arising as to whether sole proprietors are governed by the Section 17A of the MACC Act. Taking directly out of the provision, sole proprietors are not governed by the provision, but it could be possible that if a sole prop gets involved or participates in any act of corruption, they could be held liable under, for example, Section 17 of the MACC Act, where it governs for individuals partaking in corruption activities. So in the end, a commercial organization is a legal person. They can't be implicated with a criminal liability. So where Section 17A provides that a commercial organization will commit an offense if a person associated with the organization gives or offers or agrees to give gratification to another person with intent to gain or retain advantage or business. So who are these associated persons? They are the directors, the partners, the employees, and also persons performing services for and on behalf of the organization. So ultimately, Section 17A makes any director, partner, employee, or such persons performing services for and on behalf of the organization liable for the offense committed by anybody in the company. So these are, on the slides, these are examples of an offense under Section 17A. You've got the offense of accepting gratification, offense of giving or accepting gratification by agent. Now, stopping right there, agent in this context means an officer of a public body. So you could even bribe an officer of a public body or foreign public officials. These amount to offenses that can fall under an offense under Section 17A. Previously, the MACC Act only focused on the prosecution of individuals involved in corruption, as I previously earlier mentioned. Under Section 17A, of the MACC Act, where anybody employed or associated with the commercial organization commits a corruption or bribery offense, whereby you give gifts or hampers or cash, or even settling a loan on behalf of another person, of another commercial organization, to obtain benefit or an advantage in business, then the associated persons, such as the directors, partners, employees, or even persons performing for and on behalf of the organization, would be deemed to have committed an offense and is subject to legal action. So how do these associated persons protect themselves, or how would one commercial organization seek to protect itself from such legal action? Ultimately, pursuant to Section 17A, the commercial organization must have in place adequate procedures to prevent the commission of the offense under the MACC Act, corruption offenses. Now, these adequate procedures must be properly and effectively enforced and communicated to all persons employed by the organization, also including other contracting parties. So, for example, if I'm contracting with a subcontractor, we are going through a corporate transaction. Perhaps one way for the organization to protect itself effectively is to allow that other party to be aware of the organization's anti-corruption policy. Also, in terms of adequate procedures, they must be in line. They are actually guided by the guidelines issued by the Prime Minister's Office, which Cassandra will actually go into detail later on. But ultimately, to protect itself from all these legal actions that may come its way, commercial organizations must have adequate procedures and proper training and communication towards all employees of the organization. Failure to prove defense, and upon conviction, well, the corporate commercial organization or persons associated with the organization would be liable to a fine of not less than 10 times the value of gratification, or 1 million ringgit, whichever is the higher. Now, obviously, the commercial organization would not be able to be imprisoned because it's a legal person. So persons associated with the organization, such as, again, directors, partners, employees, or other persons who are performing services for and on behalf, would likely be liable to an imprisonment for a term not exceeding 20 years, or could be also liable to a fine, as above. Adding on to the previous slide, whatever I mentioned earlier, it's pertaining to the defense by the commercial organization. What about associated persons who have been charged with the offense? Now, it is important for these associated persons to actually prove that they have no knowledge or they have not given consent to such conduct by other employees or the people who are involved in the corruption activity. And also they must prove that they have exercised due diligence to prevent such commission of corruption offenses. Ultimately, even failing to prove your defense, it is important that, for example, if you are employed by a commercial organization, you are being offered gratification by another person from another commercial organization, or even an officer of a public body, for example. Please help me out. This is something for you to be encouraged to help me out in this certain matters. So these people who are actually being offered gratification, they actually have an obligation to report such gratification to the MACC, the nearest MACC office or a police officer. Now, this is a reporting obligation under Section 25 of the Act. If you fail to report and you are actually found to be involved in or being offered such gratification, and if you're found to have failed to report such offer, you're actually liable to a fine of not more than 100,000 ringgit or an imprisonment for a term of not more than 10 years or both. So ultimately, with the introduction of Section 17A, the MACC is actually very, very strict, implement or carry out its exercise of its powers to fight corruption within the business world. It is also important to note that the provision comes into force today, and it is very, very vital that commercial organizations have or are going to prepare proper adequate procedures and anti-corruption policies to be enforced within the commercial organization itself. And it is not just simply implementing and enforcing or just putting it there. It is also important that these procedures and policies against corruption within the commercial organization has to be communicated to all employees and other contracting parties with the organization. And employees also must be trained on a biannually basis or even an annual basis. It is important for commercial organizations to actually adhere to its obligations under the Act. With that being said, I'd like to hand the time back to Felicia, who will introduce briefly our next speaker, Cassandra. Thank you.
Thank you for your insights, Tommy. We'll now hand the floor to Cassandra, who will speak on adequate procedures.
Thanks very much, Felicia, for that introduction. And thank you very, very much, Tommy, as well, for introducing the introduction of Section 17A as well. I will share my screen with all of you now so we can go through adequate procedures. Right, so I think Tommy has given all of us a brief introduction on what Section 17A is all about and exactly what it entails under the MACC Act. Now, in furtherance to that as well, the Prime Minister's Office has also given us guidelines to help commercial organizations essentially come up with something called adequate procedures. Now, I think some of you might actually ask what is adequate procedures, and a lot of people have a lot of concerns as to what exactly it entails. Now, the adequate procedures are essentially just a body of guidelines, and it's not meant to serve exactly a copy and paste situation of what the guidelines are. It is an implementation of internal policies that must be implemented within each commercial organization. And within such organizations, of course, depending on the size, they should be able to implement internal policies or enforce and monitor them by way of procedures that they have in place to follow adequate procedure guidelines. Now, the burden is normally on commercial organizations. It's their burden of proof to show that they have prepared, communicate them, and implemented it as well. It is not enough to say that the commercial organization had intended to provide adequate procedures or guidelines, but they haven't. So what essentially this means is that guidelines have been issued and commercial organizations are expected to have those drafted immediately, given that, as Tommy said, today is the first day, in fact, that it has come into force, being the 1st of June. So before that, we will dive right in as to what exactly adequate procedures are and how you essentially might want to have them prepared. Now, again, the MACC Act, as Tommy previously introduced, it does not define adequate procedures. Again, the adequate procedures is a separate document, which is a guideline issued by the Prime Minister's Office. And these guidelines provide details and steps as to how exactly we are to prepare and implement them. These guidelines are in fact in line with Section 17A. It's not an all-comprehensive guideline, of course. There are other procedures which a lot of corporations, especially public listed companies, have gone extend further to essentially increase their procedures and guidelines to make sure that it's an all-encompassing guidelines so that people don't exactly fall foul of this Section 17A, which is quite hefty, the fines if found liable. Now, with that being said, under adequate procedures, the issues of guidelines, there are a few steps that must be taken. An example of this is the trust principles, which we will go into quite some depth after this in the following slides. Other procedures which everyone might want to take into consideration is whistleblowing policies, which we will also briefly touch on, anti-corruption and anti-bribery policies, which are internal and external, and can be communicated by way of emails or by website or by way of handbooks that the companies will issue out to their employees. Guidelines which the Prime Minister's office had essentially issued were based on the principles of trust, which is TRUST. Now, trust starts with top-level commitment. It then goes on to risk assessment, undertaking control measures, a systematic review, monitoring, and enforcement policy, and training and communication, which is very important. So the first and the last one, both which starts with T actually, which is top-level commitment, and training and communication is very important in order to use adequate procedures as a defense in the event any organization is found liable under Section 17A. Now, the objective of these guidelines which were issued is merely to assist commercial organizations in implementing the adequate procedures. Bear in mind, these guidelines are not a piece of policy, and it's not a set drafted policy that you can copy and paste again and put on your website. It needs to be carefully drafted to include these principles, which you essentially see on the screen now based on TRUST, trust principles. An effective method of doing this is to follow these guidelines step by step to ensure that each piece of principle is followed and drafted carefully to suit your organization and to suit the needs of your employees as well. Without further ado, we'll go into the first one. So if previous slide, we start with TRUST. So the first being top-level commitment. Top-level commitment requires every commercial organization's top-level management. Now, this includes your directors. If it's a company, it includes your partners. If you're in a partnership, it also includes top-level management, such as senior management, head of departments especially. And these people need to ensure that only the highest level of integrity and ethics is essentially practiced within your company and within your organization. It is the top-level management's duty to not only come up and implement or establish their internal policies, but they must also ensure that it is maintained from time to time. So when we talk about maintenance, we also refer to that policies must be reviewed quite frequently so that they ensure that any new updates that come into force is taken into consideration. It must be communicated to all staff. Again, we reiterate that it is not merely enough for them to come up with internal policies and procedures, and only the directors and top-level management know about it. All members of staff and all members or people associated with these organizations must know about your policies which have been in place in your company or your organization. Now, a way to do this is that a lot of companies, we see that they put disclaimers on their website where it's a link that you can click and you can view their whistleblowing policies, their anti-corruption policies directly online. Now, this is an effective way to communicate whatever internal policies these organizations have, because effectively third parties and third contracting parties which enter into contracts with your organization will be able to view these policies online, so that they will be able to know that you do have an anti-corruption and bribery policy in place, and they will be able to review this online as well from time to time in the event they are amended. Now, top-level management, especially all your directors, must have a first-hand knowledge of everything that goes on in the company. They have to oversee all the corruption risks that may potentially happen within the company. Now, this, of course, leads us to our second principle, which is with risk assessment. And this risk assessment must be taken on board across the board throughout the entire organization and implemented by the top-level management. Now, to identify mitigating risks which the corporation might have would severely depend on whether you're a big size organization or a small one. For smaller private limited companies, your risk assessment might not be that big to conduct, especially when you want to do your audited accounts. However, this is a vast comparison to those companies such as public listed companies or slightly larger organizations where you have between more than 50 to 150 employees. Now, your risk assessment would essentially need to cover all transactions which the company has. What you are essentially looking for under your risk assessment is to see whether the company has any transactions with other countries or contracts that are based in different jurisdictions where those countries have a high corruption risk. Now, those are transactions that you might want to comb with a very fine comb to go through to ensure that your risk assessments are all in place and that your guidelines are clear. Now, lack of top-level management, especially during your risk assessment stage, will affect finances in future down the line, because your control of finances should be done by your top-level management. So if there is a lack of guidance and if there is a lack of leadership in your organization in terms of finances, this obviously will lead to corruption activities within the company, which they may not know of from every single employee. Now, the problem with doing this essentially is that risk assessments should be conducted not only once, which is, say, for example, we're now on the 1st of June and companies conduct a risk assessment by December. It's not enough for them to do it once and then for the next 5 to 10 years, they're deemed risk-free. That's not obviously how it works. The adequate procedures was put into place so that risk assessments can be conducted periodically. Now, it is said that for good practice, periodically means risk assessments should be conducted every 3 years or so at the minimum. And every individual staff or employee should be reviewed in terms of performances and especially in the accounts department, what they have signed off, money's going in and money's going out with transactions that are important for the organization. And top-level management should also consider looking into systems that they should implement to check and balance. Now, an example of this is very clear in a lot of slightly larger organizations where they use finance signatories in the span of more than 2 to 3 signatories. This is either to limit the amount of signatories to sign off on accounts going in and out, or this is included to include a few signatories at the very least to approve all incoming and outgoing funds to minimize risk. Now, this is very important, especially if you're in a situation where companies have between 5 to 10 directors. Risk assessment includes not only doing background checks on your directors, of course, but it also includes ensuring that all your directors are abiding by its own internal policies as well. It's not enough to overlook employees and staff of your company. You need to go a step further to ensuring that all directors are also on the same page and they're all aware of the risks that are involved given this new Section 17A. The next adequate procedure that we're going to look at is to undertake control measures. Now, control measures in a situation where you have a big organization would obviously be a harder burden to bear as compared to those which are slightly smaller organizations. They need to have the appropriate controls and contingency measures. What I mean by contingency measures, sorry, that's a bit of a tongue twister there. Contingency measures essentially mean that you need to be able to have a policy that ensures that in the event something goes wrong, such as your anti-corruption policy picks up on something, or your compliance program, or your policies and procedures, and there is an issue with it, you need to encourage whistleblowing. So your control measures would mean that you have internal committees, disciplinary committees in place, anti-corruption policies in place to ensure that your control measures actually work. These need to be done as well, because your enforcement would not make any sense with all these policies if there's no enforcement there or there is no control measures to ensure that the policies work. We've given an example, as you can see on the slide. It's called ISO 37001. It's an anti-bribery management system which some larger commercial organizations have chosen to sign up for. Now, this is an anti-bribery management system that captures finances and accounts that go in and out to see what transactions are high risk and what are not. Other examples apart from this include conducting due diligence when you enter into all third-party contracts to ensure that third parties are aware of your anti-corruption policies. And likewise as well, you need to be more knowledgeable on third parties anti-corruption compliance programs. Not all policies and procedures will be exactly identical, and not all organizations would have the same policies, obviously. So different organizations, like I said earlier, depending on the size, would vary, and different organizations would also have different reporting channels. A very clear example of this is slightly bigger organizations like the OSK Group. They encourage whistleblowing through a reporting channel. Now, their reporting channel is via email or a hotline number. So if any employees comes across any corruption activities or any bribery offenses that might have taken place within the commercial organization, they have a dedicated email and hotline number that they can call. And this is essentially done to ensure confidentiality on the identity of the reporter. And that's the whole purpose behind whistleblowing as well, to encourage it. This is some examples of what some bigger and larger corporations have done, together with anti-bribery management systems as well. So second last adequate procedure, which is issued under the guidelines, is the systematic review, monitoring, and enforcement principle. This principle essentially is there to ensure that all policies must have a monitoring and enforcement system. Any corruption policies, anti-corruption policies that you have must be assessed over a period of time. Performance, efficiency, and effectiveness. It is not good enough, I think after the implementation of Section 17A, it is not good enough anymore for us to turn around and say that we didn't know of the policy, or the policy was in place, but there was no enforcement or review of it after 5 years. So that's not acceptable anymore. So top level management must take the initiative to ensure that your policies are, first of all, implemented. Second of all, they are monitored. And third of all, they are also enforced over a period of time. You want to ensure that all your guidelines, policies, and measures which you put into place are able of being enforced. So you shouldn't put guidelines in your anti-corruption policies which you don't see that can or essentially be effectively enforced at all. You want to ensure that they are efficient and effective at the same time. And a lot of companies also, what they essentially end up doing is they create an internal disciplinary committee or an internal anti-corruption committee. Now this can comprise of essentially 5 to 6 board directors, or it could be a mix of both board directors and top level management in terms of heads of department, to ensure that everything within the company is running smoothly, including its internal policies. Another issue that a lot of commercial organizations also fail to realize is that they do not ensure the auditing of accounts or financial statements is thoroughly monitored. I think with Section 17A coming into force today, a lot of directors are also going to be very wary of how their financial statements are going to be prepared, especially with their auditors. They need to ensure that firstly, of course, they are prepared, and secondly, it's not enough anymore for directors to turn around and say, audited accounts was prepared, but we didn't really get a chance to look at it, but the auditors should have gotten it right. This leads back to the essential guidelines of what adequate procedures are. Adequate procedures means that essentially to combat corruption, the guidelines need to be followed to ensure that corruption does not occur within as well. So it is always important to include that funds incoming funds and outgoing funds are also approved by directors so that they know what's happening within the commercial organization. It will help to set up internal committees greatly. This is a very important point to stress. And internal committees should be independent in the sense that it is advisable perhaps to have a mix of directors and head of departments included in your internal committees to ensure that there is a there's an even playing field amongst all ranks within your employees of the corporation, and that whistleblowers will feel free to come and address issues to these internal committees, regardless of whether they're directors or heads of department or employees from within the commercial organization who have been handpicked to be part of this internal committee as well, to oversee that all internal policies are being monitored. Some companies take harsh actions against failure to comply with their anti-corruption policies, and these measures most of the time result in disciplinary action, that is essentially a matter for the commercial organization to determine. It could be a situation where some of them prefer disciplinary action, harsher ones, and it could be a situation where some of them do different measures. So it's really up to you what your company feels they should do. The last principle is training and communication. Training and communication, again, must be done periodically. They should include both internal and external training sessions, and they are expected to train and communicate all its policies and compliance programs to all associated persons. As Tommy has previously indicated, who those associated persons are, they must be trained, they must be aware of all the policies that have been implemented within the company. And it also applies to all contracting third parties. So an example of this is, say, for example, if you have entered into a construction contract with a contracting third party or a subcon or a subcontractor, you need to ensure that they too are aware of your policies relating to anti-corruption or bribery. And these also, it is very much common to see a lot of corporations nowadays uploading their anti-corruption policies and bribery policies on its website to ensure that there are no corruption activities that go on within their employees without the top level management's consent. Okay, so trust principles, which we have just gone through, essentially involve guidance steps. Like I said earlier, they are not a measure that you can copy and paste in terms of a standard policy. You have to draft them on your own, depending on what level of monitoring as well you want to do. And depending on your size of your organization, like I said earlier, different companies will implement different policies. Bigger companies, I think the example I used earlier was OSK Group Holdings. They have a very comprehensive handbook, which is also available online. And that handbook includes a variety of policies. It includes 1, an anti-corruption policy, an anti-bribery policy, and 3, it also includes a whistleblowing policy. They have a standalone whistleblowing policy as well. All these 3 policies, if I'm not mistaken, I think they also have some more. All their policies and procedures have been lumped together into a form of a handbook. And this handbook in totality sums up all the adequate procedures which they have already implemented and which they have in place for top-level management to review and for top-level management to enforce. And this essentially fosters strict compliance with Section 17A. It is a great defense for them to have because they have it very well drafted, and it includes all their anti-corruption programs and policies into one handbook, which is quite lengthy. So it really, like I said again, it really depends on the size of your organization and what your nature of business is, depending on what you do. It would also depend on whether you have a lot of contracts that you have entered into or whether you have a small business. So that will also affect your extent of drafting when you do your adequate procedures as well. We're going to touch very briefly on corporate liability. So in the past, corporate liability included offences under the Malaysian Anti-Corruption Act 2009. There are various other offences which amount to criminal corporate liability as well. There is criminal liability for misstatement in prospectus. This is mainly a reference to public listed companies, which is under Section 167 of the Companies Act. There are various other corporate liabilities as well, not criminal, corporate liabilities under the Companies Act for failure to submit financial statements, for example, on behalf of the directors, and to ensure that the audited financial accounts are submitted to SSM on time. Other liabilities which were included in the past also included franchise businesses operating without proper registration under the Franchise Act and using false trade for description of goods under the Trade Descriptions Act. Now, these corporate liabilities all still exist, but in addition to that, we now have Section 17A as well. Not to say to give us a bigger headache, but to add to corporate liability. So this essentially means that a lot of companies now, especially big commercial organizations, must ensure that their policies are drafted and implemented now. The 1st of June implies that the enforcement date has already started as well, which means that if you have not done your adequate policies, if you don't have an anti-corruption policy within your commercial organization, it is best to do it now as compared to later as an afterthought. Offenses under Section 17A, as Tommy previously highlighted, means that your directors of your companies now will now be liable for corruption activities, regardless of whether they had known about it, if there are no adequate procedures in place. As companies and commercial organizations are legal persons, again, because they obviously cannot be imprisoned, what will end up happening is MACC will then obviously come after the directors of the company as being personally liable for criminal liability on behalf of employees who have engaged in corruption activities to benefit the company. So in this aspect, obviously the stakes are very high, but like Tommy said earlier, adequate procedures is a defense to show that you have implemented, you have monitored, and you have enforced procedures internally amongst all your employees and staff to ensure that corruption activities does not exist within your company. As long as that is done, that would obviously give directors more comfort in knowing that they have implemented the adequate procedures they need to avoid such liability in future. What we'll do is, I think I'll summarize everything of what we have gone through so that we can take questions. The objective of corporate liability under Section 17A essentially is to combat corruption activities. I don't think it is to penalize directors for companies unfairly. I think the MACC Act, especially Section 17A, is worded in a way where corporate liability is there so that corruption activities don't fester. Although there may be challenges ahead in the early stages of enforcement, which we will obviously definitely see in months to come, because today is only the 1st of June, commercial organizations should still ensure that all their corruption practices, anti-corruption practices and policies are prepared now, and their policies are drafted now efficiently and effectively and not later. Previously, there was a proposal to suspend and or delay the enforcement of this section due to the COVID-19 pandemic and the MCO, and a lot of people had actually advocated for this to be postponed. Unfortunately, the Prime Minister's office had on the 21st of May announced that Section 17 is in fact coming to force as planned, and today, which is the 1st of June, is the day it comes into force. So if you have any further questions, you can feel free to type your questions up on Slido and let us know. We're happy to answer it within the next 15 to 20 minutes. If you would like to know further information on the adequate procedures that we have just explained to you, you can feel free to ask us questions or contact us. I think that's all for now. My time is up, so we will go to questions. Felicia.
Thank you, Cassandra and Tommy, for sharing with us about corporate liability under Section 17A. We will now take questions from the participants on Slido. The first question we have here is, what if my company gives referral fees to people who bring business to the company? Would this amount to corruption? Tommy, would you like to answer this question?
Thank you, Felicia. Technically, well, it's quite gray. It's quite gray of an area, but in order to safeguard your own company from any potential risk to be found liable for corruption offenses, the company could always enter into a introducer's agreement with the referrer for any referrals from him to the company.
Thank you, Tommy. Cassandra, do you have anything to add to that?
Yeah, I do actually. I think this is more of a business standpoint, and it's more of a business transaction. So say, for example, if, like Tommy said earlier, if you have your contractual relationships for referral fees, especially in the private sector, such as introducer agreements, I think that amounts to business transactions. And as long as you have your internal agreements between both parties in place and both parties agree, then that obviously becomes a contractual agreement between both parties, and it won't fall under Section 17A, save and except unless, you know, an employee of your company has gone ahead and entered into an introducer agreement without the director's knowledge, then that might be a different story.
Thank you, Cassandra. Next question we have here is, during festival seasons, companies like to send out hampers and gifts to potential clients hoping to get more business in the future, would this be caught under the Act as well? Tommy?
Well, in relation to this question, even the question itself already would make it quite clear that it will be under the purview of the new Section 17A, because even if it's a festive season, companies want to send hampers and gifts to their clients, hoping to get more business. That is already in line with the provision that there's intent to gain or retain business or an advantage in the conduct of business. Now, hampers and gifts are considered gratification under the Act. So directly answering this question, yes, it would be under the Act, under Section 17A.
Sorry, if I could just add to that. Say, for example, your intention is to give a Hari Raya hamper or a Chinese New Year gift. Now, we're very well aware that a lot of companies do that. They even send Hari Raya notes, or they send, those big hampers. That is actually fine as long as there is no intention to gratify another company or another person in hopes of getting a personal gain or personal advantage. Now, it is also important that under Section 17A, the intention of doing that is very clear. If you've had a long withstanding client for 25 years, let's take the law firm, for example. If we've had a long-standing client 25 years and we send that client a Chinese New Year hamper, so our intention obviously is not to promote ourselves to get an advantage in the business. The intention there obviously is a goodwill intention during a festive period. So I think there's a difference here in how you look at it and how you approach it.
To even add further to it, the MACC has also has its service circular. So under paragraph 5 of the service circular, public officials are not allowed to receive hampers or gifts even during festive seasons, because it could be directly in line again with their official dealings in their position. Now, what if they receive gifts otherwise that are not in direct relation to their official positions? Civil servants can receive gifts that is 1/4 of their salary, or not more than 500 ringgit. If they receive such gifts in their personal capacity, nothing to do with their positions or whatsoever, they would have to report to their head of department.
All right, thank you, Cassandra and Tommy, for your thoughts. The next question we have here is, if a person who commit corruption on personal gains without the management's consent, would this be unfair for the associates who will be automatically found guilty of such offenses? What are your thoughts? Tommy, would you like to share with us your thoughts?
Like Cassandra presented earlier or mentioned earlier, that the adequate procedures are based on the trust principles. So in effect, the top level management of a company or commercial organization must be well aware of every transaction and dealings that's going in and out of the company. So again, if the director, partner, or whoever gets is held liable against such offenses, there's a defense for them to rely on, that such corruption activities were committed without their knowledge or consent, and they have also exercised due diligence in hopes to prevent the commission of such offenses.
Thank you, Tommy. The next question we have from we is that, can we share a copy of the PMO guidelines to prepare and implement adequate policies? We will share a link to the guidelines in the chat box in Zoom at the end of this talk. The next question we have here from BK is that, will this new Section 17A affect the committee members of GMB or MC in a strata development scenario? Tommy, would you like to answer this question as well?
Under the new Section 17A, I've previously mentioned what is defined under commercial organizations. So it relates to commercial organizations, relate to companies, foreign companies having businesses here, partnerships and limited liability partnerships. Now, the section does not provide for JMB or JMCs, but if individuals do partake in corruption offenses, they could be held personally liable under the other provisions under the Act.
Thank you, Tommy. So the next question we have here is, if a partner or director issues a check out of their personal name instead of using the company's name to perform a pecuniary advantage, will the law let the company off the hook? Cassandra, would you like to answer this question?
This is a very interesting question. So in the event the partner or director personally issues a check, yes, they can still be liable. The answer is outright yes, but provided that pecuniary advantage is very clear and linked back to the organization. So because he already has capacity as a director under the company, regardless of whether he issues that monies out, he is doing it for an advantage purely for gain, and he's doing it purely for the benefit of essentially the company. So the company is benefiting from it, regardless of whether the director has paid out for it. Now, whether or not the director will be penalized, whether the commercial organization will be penalized for it, that is a subjective question, which will depend on the circumstances surrounding it. Personally, the director will be liable, though, most likely. But in terms of the commercial organization, that would definitely depend on the circumstances surrounding that advantage which was gained by the organization.
Okay, thank you, Cassandra. The next question here we have, I'll rephrase this question for clarity. It says, will there be a penalty for someone who has been found guilty of abetting an offense or being an accomplice to an offense under the MACC Act? And if so, would there be a penalty in an amount which is lesser than the main offender? Cassandra, would you like to answer this question?
So I think this does not relate to Section 17A. This is relates to the main body of MACC Act in general, which has already been in force for quite a number of years. Under Section 17A specifically, though, the person who is aiding or abetting, perhaps, which is what they're asking, if I'm not mistaken, would depend on whether that person is also an employee of the organization, because Section 17A specifically relates to a commercial organization and persons associated with it. So persons associated, there must be some sort of link between them and the person. So say, for example, I'll give you an example. If the person aiding and abetting is an agent for a property agency, and that agent obviously is an associated person. If the person aiding and abetting is perhaps the sister of the person who works in that company, then that might be circumstantial and subjective. So it depends who the person is and what their link is, whether they fall under an associated person to that commercial organization.
Okay, thank you, Cassandra, for your thoughts. Next question we have here is, will it impose to an employee with EPF and SOCSO and commission agent or contractor who is without EPF and SOCSO, or both? It should say, will the Act apply to employees who has EPF and SOCSO, and also commission agent or contractors? Tommy, would you like?
Well, under Section 17A, again, associated persons could also be persons who are performing services for and on behalf of the company, whether it could be under a contract for service or contract of service. So obviously, again, the top level management must be well aware of all contracting parties and also employees within the organization, that financial transactions going in and out of the organizations is well documented, and is also and such transactions are authorized with knowledge of what the purpose is for.
Okay, thank you, Tommy. We have a question from Mr. Chan. It says, the Section 16 and 17A apply to the board of directors in a company after they've been sacked. And also when they are no longer in the company, will corporate liability still be acted upon them?
I can take this question.
Okay, sure.
I would believe that this question is pertaining to, let's say, a director who's in a company and thereafter he leaves or is sacked from the company, and as such would the provision apply to him? Well, it is important to note that Section 17A is governing the offense of corruption, and then would also hold liable the persons associated, for example, directors, partners, liable for the offense at the time that it was committed. So, for example, if the director in question was still employed in the company on, let's say June this month 2020, and there was a commission of a corruption offense in July. Thereafter, in December 2020, the director is sacked, and it is found that there's a commission of a corruption offense in July during his employment with the company. Then yes, he will still be held liable under the provision.
Thank you, Tommy. Next question is from Mr. Jason Yen. Does it mean that companies can never do business development?
Well, companies can do business development so long as there's no offer of gratification or receipt of gratification with intent to gain advantage over other companies. At least that's what Section 17A says. The whole entire purpose of the new provision coming into effect is to really get rid of corruption practices within the business community. Well, business development can be done in good faith. You got your online marketing avenues, different avenues to do business development. In relation to this question, I don't think that business development solely and is directly related to giving gifts or settling loans for other people. So companies can do business development, but on a cleaner side.
Cassandra, this is a really interesting question. Do you have anything to add to that?
I think it's a very fine line here for a lot of businesses. They're going to have to be very skeptical from now on what their business development approach are. Of course, it's not enough anymore that you take public officials, especially out for dinners. You never know when that might be perceived in a bad light. So I think companies need to tread carefully. Again, intention is very important, especially with your adequate procedures. So it really depends who you're dealing with, what your business development approach is. But to answer the question outright, no, it does not mean business development cannot be done anymore. It's just, I think, safer to do it in a different method and a different form, especially if it doesn't involve gratification. And that's something that a lot of companies should really start to reconsider and look at their approach slightly differently.
Thank you, Cassandra. Due to time constraints, we'll be answering the next two questions. Next question we have here is, how about sponsorship for clients' annual dinner?
Again, it's quite a fine line. Well, sponsorships can be considered as donation, but if the client is a long-standing client and your business relationship is actually very, very good, you can sponsor an annual dinner on a goodwill basis, and also if you can prove that there's no intent to gain business advantage or to gain additional business, again, it's basically strongly in relation to your intent for that conduct itself.
All right, thank you, Tommy. The last question we have here is along a similar line, which says, can we buy vouchers to our customers? Will this fall under the MACC Act? Cassandra and Tommy?
I buy vouchers for customers. Well, I don't quite understand buying vouchers for customers, but, well, again, intent, I would say. Again, the gifts or vouchers or anything, any asset that has monetary value, no matter how big or small, can be considered as gratification, especially when there is an intent to gain business or to procure business advantage from third parties that you're actually dealing with.
All right, thank you, Tommy.
Actually, so just before that, I think Mr. Chan has a second question, which we may not have addressed earlier. My apologies for that. I think his question was in relation to the aiding and abetting question that I answered previously. He wanted to know if the quantum is less for an abettor. Now, under Section 17A, the answer is there is no direct meaning for abettor under Section 17A. It relates mainly to the MACC Act, and there is no quantum for what amount of penalization less there is for an abettor. That's silent, and that is circumstantial, and that is subjective. Essentially, that would obviously relate to a criminal liability matter. So in terms of quantum, no, it's not. There's no specification on quantum under Section 17A.
All right, thank you.
Also, I've seen a follow-up question by, I think, Mr. or Miss Wee, saying that would any gifts of any value amount to, yes, that one. Is it safe to say that you're not committing any offense despite regularly buying meals, gifts, as long as you don't gain anything from that person? Well, again, then this would be directly in line with intention, or whether your purchase of gifts is directly in line with the person's official position or dealings. Again, as I previously mentioned in my answer to a previous question, anything that has monetary value, whether be it 100,000 ringgit or 50 ringgit, 100 ringgit, it is still considered gratification if there is intent. You don't have to gain anything from that person, but as long as you have intent to gain something out of it, then you are very much likely to be found liable if you're reported. I hope that answers.
Sorry, I could just add to that. I think for the purposes of all our participants here today, what I think it's important to remember that this Section 17A, it relates to the Malaysian Anti-Corruption Act. Now, the very principle of corruption relates to whether something is a bribe and whether something is corrupt. So I think to make it simpler in terms of words, a very good example would be, say, for example, if you're tendering for a project and there are a few companies who are tendering for that project. Now, the corruption and bribery exist in the fact that you are obviously offering meals and gifts as an incentive to up your position for that advantage to obtain that tender. Now, while you may not necessarily obtain that tender entirely, that giving of a gift or buying vouchers or whatever it may be may amount to that bribery. But if it's a completely private sector, I think this is very circumstantial. If it's absolutely relating to two private sectors where there is no tender of contracts involved and there is no contracting third party involved with the person that you're obviously buying a meal for, then I suppose that is obviously circumstantial and subjective. So depending on what your accusation of corruption is, then it is only an offense if someone has significantly lost out because of you buying that person a meal or a gift. I think that's what it means, because we have to always relate it back to the corruption aspect of it.
Thank you, Cassandra, for sharing. Before we conclude, I have a few announcements to make. First, please join us again for our upcoming talks. On Wednesday, the 17th of June, we have a talk on the basics of contract law for construction consultancy contracts by a partner from our firm, Ms. Christine To, and together with a guest speaker, Mr. Edmund. You may sign up to the upcoming talk at our website with the link or the QR code here on the screen. Secondly, please fill in our feedback form and tell us what you thought about today's talk. The link to the form will be posted in the chat box here. We appreciate your feedback so that we can continue to improve our MWKA online talk series for you in the future. You may also submit your questions in the feedback form, and our speakers will address them by email. Thirdly, follow or like our social media accounts. You may find the links to our social media accounts in the chat box as well. Fourthly, if you would like to speak with our lawyers, we offer a complimentary consultation or 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box. To our guests, thank you for joining us today. We hope you found today's session informative and useful. Thank you, everybody, and see you at our next talk. Stay safe and have a great day.